Here today for sentencing. State of Ohio has had the opportunity to review the pre-sentence investigation report and is prepared to go forward. Thank you.
Your Honor, Mr. Tottarella is 61 years old. After talking to him and reviewing his pre-sentence report, he certainly has had a challenging life, to say the least, starting with his childhood. Things were not well in his household. I think there was some mention in there about being exposed to alcohol back when he was very, very young. He's been exposed to drugs his entire life, Your Honor. Facts of the cases that bring us here today, driving under suspension, those stem, unfortunately, from an aggravated vehicular homicide for which he served 9 years in prison. Your Honor, he was in prison times before that, so he's no stranger to the prison system and the prison culture, Your Honor. He'd like to do something to rectify that. Hopefully, the fact that he was driving, I think, in one of these cases, he was going to get something to eat and helping a friend move a vehicle. But as he has stated to me, and I think he's put in his pre-sentence report as well, the unfortunate victim in the vehicular homicide can never come back to life. Neither should his driver's license, and he wants to be cognizant of that fact, and he's well aware that it is a lifetime suspension, and he needs to take that very, very seriously. He's also relayed to me that while he's been in the Lake County Jail, informed that he has some sort of a heart condition for which he's prescribed some type of heart medication. He also receives lithium at the jail. He's been under the care of Crossroads and has had depression and anxiety. These have been struggles throughout his life, Your Honor. Not only that, due to the friction and issues in the home, it appears he's only obtained a 5th grade education. I don't think anyone else in here can even imagine what that would be like.
This is where the courtroom starts painting two completely different pictures of the same man. On one side, the defense is laying out a lifetime of hardship, drug exposure as a child, mental health struggles, a 5th grade education, prison culture, addiction, heart problems. And legally, that matters during sentencing because judges are supposed to consider not just the crime itself, but the defendant's background, likelihood of rehabilitation, and overall circumstances. But here's what makes this case emotionally complicated. The court also has to weigh public safety. A lifetime suspension isn't some technical paperwork issue. It was imposed because someone lost their life. So the audience has to ask themselves, how much should personal hardship reduce accountability when the underlying offense involved a fatality?
It's not even the issue of going through 8th grade or 9th grade, but he hasn't even obtained the abilities that we take for granted, such as reading and writing. I'm sure that has made life frustrating and difficult. If he were to be placed on community control, which is what he is asking for by this court.
Mr. Tottarella, what do you want to tell me before I impose sentence?
I'd like to say, first and foremost, judges, I'm ashamed to be in front of you again. I do know the significance to driving under a lifetime suspension. I did, I got a charge of aggravated vehicular homicide many, many years ago, and a person that was dear to me died. And because of that, the judge imposed 9 years out of Cuyahoga. It was a Cuyahoga judge. Along with that sentence was a lifetime suspension. And I didn't realize at the time what that suspension means. Don Escape actually died from a decision I made, Your Honor, and I was granted my life back, my freedom. Therefore, my driver's license must stay to the world of the dead also. I also realized when a Cuyahoga judge imposed that kind of suspension on me, and I took for granted it was disrespectful to that judge. And with respect to this court, I'm going to say it the way I feel it. I might as well just have went ahead and slapped the damn judge in the face. I didn't know that then.
That may have been the most raw moment of the entire hearing so far. Listen carefully to what he's saying here. He's finally acknowledging the emotional and legal weight of that lifetime suspension. When he says his driver's license should stay with the dead, that's not legal language. That's guilt talking. And then he goes even further by admitting that ignoring the suspension was basically disrespecting the original judge's order. Those kinds of statements can absolutely influence sentencing because judges often look for genuine remorse. But remorse alone usually isn't enough. Courts also look at behavior after release, and that's where things become a major problem for him. Because if someone repeatedly violates the same restriction over and over again, eventually the judge starts seeing words as meaningless. Do you think this apology sounded sincere, or was it already too late to matter?
I didn't realize that then. But I understand it now, and as far as that van, I could care less about it. I could show this court more that I could complete probation. No dirty urines, no catching cases. Whatever this court imposes on me, I will do. The stuff that my attorney has said to you is all true. You know, I also want to indicate to you at my age, I let a demon go many, many years ago, Judge. I don't want to find that demon again to survive being in the penitentiary. I don't have the health I used to have. And if I could be just given another shot to prove myself, I think that I can make this court proud. I will make the court proud. That's all I have to say, Your Honor.
Mr. Gregorich?
Thank you, Your Honor. State of Iowa Trust Court fashion a sentence that's appropriate and consistent with other offenders. Thank you.
All right, I've reviewed the pre-sentence report. You've got a long history of felony criminal offenses, serious, F1s and F2s, under one number on 3 separate burglary cases for 3.5 years in 86 to 89. Went back on a robbery in 94 until 01. A couple months later, picked up a kidnapping and a felonious. Went to prison from 02 to 08, December of 08. December 25th of 08, an abduction. Assault. Went to prison for that. Well, included in that was the vehicular homicide, aggravated vehicular homicide. So got out December 22nd of 17, so 9 years. 9 years you were locked up on that. Put on parole.
Now, the judge is doing something extremely important here. He's building a sentencing record step by step. Notice how methodically he walks through every prior conviction, prison term, parole violation, and driving offense. That's not just for dramatic effect. Judges often create a detailed record like this to justify why a harsher sentence is necessary, especially if the case could later be appealed. And honestly, this timeline is devastating. The court is basically showing a pattern that stretches across decades. Burglary, robbery, kidnapping, aggravated vehicular homicide, drug violations, probation violations, and then repeated driving under suspension almost immediately after release. At this point, the judge isn't viewing this as one mistake. He's viewing it as a continuous refusal to obey court orders. And when a judge loses confidence that supervision will work, prison becomes much more likely.
Caught driving under suspension in June of 18, so 6 months after you got out in Menor, you were given a verbal reprimand, whatever the hell that means, by parole. And then in January of 21, another driving under suspension. The parole authority ordered you to follow all court orders and obtain your driver's license, so they weren't paying attention to much of anything, as usual. February of 21, you pick up an aggravated trafficking here, put on probation, violated for methamphetamine. Now we got this, October 18th of last year, driving under this suspension, this lifetime suspension. Less than 4 months later, driving under suspension again in Eastlake, both in Eastlake. In 09, you were given a lifetime suspension, and 4 times since then, you're driving under suspension. For some reason, because you wanted to drive. I mean, that's the only reason, is because you wanted to. So you talk about following court orders. You don't follow orders. You You wanted to go to McDonald's to get something to eat, so you went to McDonald's to get something to eat.
I never made it to
Well,
McDonald's, Judge.
that's where you were going. So the only reason the reason you report you got in the car is you wanted to.
This exchange right here is where the hearing completely shifts tone. The defendant keeps saying, "Not anymore." But the judge immediately pushes back with the obvious question. If you understood the rules now, why didn't you understand them after the first arrest, or the second, or the third? That's the core issue destroying his credibility in real time. And legally speaking, credibility matters a lot during sentencing because community control, what many people call probation, depends heavily on whether the court believes the defendant will actually comply. The judge even points out something viewers at home are probably thinking too. He likely drove far more than 4 times and simply got caught 4 times. That's a brutal observation. But from the court's perspective, repeated violations make future promises hard to trust.
Get something to eat, and you got picked up. That was the second time. So you just keep doing it.
Not anymore, Judge.
What?
Not anymore.
You didn't what?
Not anymore, Judge.
Not anymore. You got a lifetime suspension for causing somebody's death, for which you served 9 years in prison.
Yes.
And since you got out of prison, you got caught driving under suspension 4 separate times.
I'm aware of that, Judge.
All right. Well, I want to make sure that you understand that, because you're telling me you won't do it anymore.
I won't. I promise you.
I don't understand why you did it the first 4 times. I'm sure you did it more than 4 times. You just got caught 4 times.
I only had the van for 3 months.
Why did you buy a van if you had a lifetime license suspension?
To be honest with you, to stay in it.
Okay. Well, then you shouldn't have driven it. I don't know what to tell you. I don't know what to tell you.
Let me show you, Judge.
What?
Let me show you, please.
What?
Please, let me show you, please.
You showed me everything you could show me when you're driving.
I understand that. Please, Judge.
This is honestly heartbreaking to watch because you can feel desperation taking over the courtroom. The defendant is practically pleading for the chance to show the judge he can change. But the judge has already reached the point where actions matter more than emotion. And then comes the line that seals the outcome. You showed me everything you could show me when you're driving. That statement is huge. The judge is basically saying the evidence of repeated behavior outweighs every promise being made today. In sentencing hearings, judges are constantly balancing mercy against protection of the public. And in this moment, you can tell the court believes the risk of future violations is simply too high. The emotional tragedy here is that both things can be true at once. Someone can be genuinely remorseful and still not be trusted.
Please. I'll show you. I swear I'll show you.
The most disturbing thing about this case is not necessarily your record. It's horrible, okay? But, and now here you are again. Here you are again.
Judge, I will not disobey the law. I'll follow any instruction, please.
You don't follow instruction, or you wouldn't have been out there driving. You don't follow instruction.
I will, please.
You don't. Okay.
I didn't. But I will, please, Judge.
So I'm going to find you're not amenable to community control. On the 26-224, I'm going to sentence you to 12 months in prison. On the 26-225, I'm going to sentence you to 18 months in prison. Those sentences will be consecutive to one another. And I find that consecutive service is necessary to protect the public from future crime and for the appropriate punishment, and it's not disproportionate to the seriousness of your conduct and the danger you pose to the public. And your history of criminal conduct demonstrates they are necessary to protect the public from future crime by you. I'll give you credit for 86 days. When you get out, you might be on post-release control for 2 years under the parole authority.
225, it'll be the forfeiture of the vehicle as per the forfeiture spec.
That vehicle's forfeited. Anything else?
Nothing, Your Honor. Thank you.
Mr. Mulkey?
Nothing, Your Honor. Thank you.
All rise.